Hello, and welcome back to Shattered Innocence, Darlene J. Clark's channel on bringing child abuse awareness. Matthew 18, verse 6, but who shall offend one of these little ones, which believe in me, it were better for him that a millstone were hanged about his neck, and that he were drowned in the sea. Due to copyright disclaimer under Section 107 of the Copyright Act 1976, allowance is made for fair use for purposes such as criticism, comment, news reporting, scholarship, and research. Fair use is use permitted by copyright statute that might otherwise be infringing. Nonprofit, educational, or personal use tips in favor, balance in favor of fair use. Thank you for coming. Hello, bucket list. You're out today. Catch a replay. Much love to you. Much love to you as well. Thank you for coming. All right. So today, now we just got there doing a Derrick Himes that was 26 years old. Now we're doing a Derrick Himes, which is Derrick Himes was 26-year-old in the previous video, and this one is 50-year-old. These crimes both happened in the state of Tennessee. So go ahead and do the setting, do the share screen. A minute, not now. Hold on. Make sure that y'all can see the full view when I go to do that. All right. Video file, screen, entire screen. Okay, this right here, is give credit to WGNSradio.com. Man who raped 12-year-old girl in Murfreesboro to remain in prison. His appeal was denied. A man convicted on 3 counts of rape of a child in Rutherford County has appealed his case to the Court of Criminal Appeals. 50-year-old Derrick Himes was convicted in 2019 by a Rutherford County Circuit Court jury for rapes he committed in 2007. Himes was also found guilty on 3 counts of aggravated sexual battery during the trial. Court documents show when Himes committed the rapes, he was 35 years old and the victim was only 12. Documents also show the child told the court she lived with her mother, grandmother, and sister when the rapes occurred. At the time, the victim recalled all kinds of people stayed in the cramped 2-bedroom apartment and that she and her sister slept in any room they could find to sleep. She recalled sleeping on the floor numerous times. Records show the child told the courts that she went to her mom to tell her about the rape incidents, and the mother allegedly accused her of trying to steal her man, calling her a liar, too. Little did the mother know that she tried to escape the grasp of Hines multiple times, according to court documents. And here is where the Tennessee courts.gov case number, a Rutherford County Circuit Court convicted the appellant Derrick Himes of 3 counts of rape of a child and 3 counts of aggravated sexual battery. Trial court imposed a sentence of 25 years for each rape of a child conviction and 8 years for each aggravated sexual battery conviction. The trial court imposed concurrent sentences of 25 years for each rape of a child conviction, concurrent sentences of 8 years for each aggravated sexual battery conviction, and ordered that the 25-year sentence and the 8-year sentence be served consecutively for a total effective sentence of 33 years. On appeal, the appellant contends that 1. The trial court erred in denying the appellant's motion for a judgment of acquittal and motion for new trial because the evidence was insufficient to sustain the convictions. 2. The trial court abused its discretion by allowing the prosecutor to elicit irrelevant and prejudicial testimony from the state's witnesses. And 3. The trial court erred in imposing consecutive sentencing. Upon review, we affirm the judgments of the trial court. Okay, so here's actually the court in the Court of Criminal Appeals of Tennessee. Appeal right here, number, and there's the judge. A Rutherford County Circuit Court jury convicted the appellant, Derrick Himes, of 3 counts of rape of a child and 3 counts of aggravated sexual battery. The trial court imposed a sentence of 25 years for each rape of a child conviction and 8 years for each aggravated sexual battery conviction. The trial court imposed concurrent sentences of 25 years of each rape of a child conviction. Okay, we read this a few minutes ago, that part. So go on down. There's an appeal as of rights judgments of the circuit court affirmed. There's the names right there. The appellant was charged with 3 counts of rape of a child, 3 counts of aggravated sexual battery, and 1 count of solicitation of sexual exploitation of a minor. Oh my gosh. See, I told y'all I wondered whether or not he did something, and I do not know if that girl was ever video recorded by this man, but it looks like that possibly got some kind of connection with that other Derrick I did earlier. We need to look into that more and try to figure that out. The charges were based upon incidents that occurred between the appellant and the minor victim, who was the daughter of the appellant's girlfriend between September 2007 and May 2008. At trial, the victim testified that she was born on December the 3rd, 1995. She attended high school through the 10th grade. The victim said that she was scared to be in court. The victim said that when she was growing up, she had 3 main people in her life: her grandmother, her mother, and her younger sister. Since the offenses, the victim's mother had not played much of a role in the victim's life, and the mother did not remember anything about the time during the incidents because she had been too high. Victim said that when she was 11 or 12, she, her mother, and her sister moved in an apartment in the Green Meadows Apartments in Murfreesboro, Tennessee. They lived in the apartment for less than 1 year. The apartment was located on the second story on the back side of the apartment complex. It had 2 bedrooms, 2 bathrooms, a laundry room, and a kitchen. The victim recalled that all kinds of people stayed in the apartment and that she and her sister slept in any room that they could find to sleep in, but the apartment was crowded. The victim said that when she slept in her mother's room, she sometimes slept on the bed and other times she slept on the floor. The victim stated that her sister often left the apartment and went to a friend's house. The victim said that while they were living at the apartment, her mother lost her job at a Chick-fil-A restaurant. The victim's mother was often away from the apartment while she was unemployed. The victim did not know where her mother would go, and she did not realize her mother was using drugs. The victim said that her mother would acknowledge that she had been using drugs at the time, but would deny being a junkie and would describe her drug use as tolerable. Of course, they always say that. The victim recalled that the appellant, whom she knew as Tank, began staying with them 1 or 2 months after they moved into the apartment. The appellant left the apartment and moved to Louisiana a few weeks before the victim and her family moved out of the apartment. The victim told the appellant said the appellant did not work while he lived with her family. A couple of weeks after the appellant moved in, the victim began referring to him as dad. The appellant seemed okay with it, and her mother agreed because she thought the appellant was going to be a father figure towards the victim and her sister. The appellant paid attention to the victim and her sister, took them out to eat, and bought them things such as food, lingerie, and clothes. The victim said that the appellant began doing inappropriate things to her. However, she could not remember when they began and could not recall the order in which the incidences occurred. The victim remembered that on one occasion the appellant entered the laundry room while she was putting clothes into the washing machine. He came up behind her, pressed against her, and rubbed his hand up her thigh. The victim pushed the appellant, stepped away from him, and left the laundry room. The victim recalled on occasion when she was in the shower and the appellant removed his clothes and stepped into the shower behind her. The appellant touched her breast with his hands, slid his hand between her legs, touched her genitals, and inserted his finger into her private part. The victim pushed the appellant's hand away and got out of the shower. She retreated to her bedroom where she was unable to find her mother. Hi there, Jackie. This is actually the court document in the Court of Criminal Appeals where this is going on. That does seem suspicious when he bought him things like lingerie. The victim remembered another occasion when the Christmas tree was still up and she was sitting with the appellant on the couch in the living room. Good to see you too, sweetie. The victim told the appellant she was happy that she had a dad, and he responded that every girl deserves a dad. The appellant rubbed her legs, including the inside of her leg, her buttocks, and all over her body on top of her clothes while they were watching TV. The appellant told her that she was special. The victim said she started accepting the abuse because she was tired of fighting with people and because she felt more like the more she tried to stop it, it was just going to happen again. The victim testified that on one occasion she and her sister had to sleep on the floor of her mother's bedroom because so many people were in the apartment. The victim slept on the floor on the appellant's side of the bed, and her sister slept on the floor on the mother's side of the bed. The victim said the appellant started rubbing her. She explained that his hand was underneath the cover but out of it where he was able to reach me. The appellant rubbed the victim's shoulder, grabbed her breast, and touched her side. He then rolled over to face her mother and fell asleep. The victim recalled another incident which occurred when she was in her bedroom and her sister was gone. Very, ain't it? It's very sad. The victim was in bed and wearing a t-shirt and underwear. The appellant came into her bedroom and got into bed with her. At some point during the incident, her underwear came off. The appellant kissed her, got on top of her, and inserted himself into her. The appellant moved in, in and out of her in a few times, trying not to say the words, During it's better for me. It was better me than my sister, and that's what I said one time when my dad, after he attacked me and raped me after the gunshot thing. So I did say that. Well, at least the rest of the kids are safe. The victim cried for her mother, but her mother did not come. The victim said that she started bleeding and did not know what to do. The appellant stopped and the victim went to the bathroom. The victim was unable to find her mother and returned to the bedroom. After the appellant penetrated in the bedroom, she tried to tell her mother what the appellant had done. Yeah, it is. The victim said that her mother got angry, called her a liar, and accused her of trying to steal her man and tried to fight her. Oh, man. just like how my mom was, when she beat my sister up when my mom walked in on my daddy raping her. She said, "You're trying to steal my man." Someone got between them and the victim ran away, fearing her mother would beat her. The victim said that she was surprised by her mother's anger. The victim said that on one occasion the appellant took her to a McDonald's restaurant to get lunch for her family. On the way to and from the restaurant, the appellant held her hand. On the return trip, he told her he loved her. It's crazy, ain't it? And see, she was into drugs, though. And that's partly part of it, too. It's horrible when they do that. They just, to tell them what all could have been done to the other sister, too. When they returned to the apartment, the appellant grabbed a white bag from his car and took the bag into the apartment. Inside the bag was a red and black sweater, which he gave to the victim's sister. Thereafter, the victim's mother and sister left the apartment. They don't deserve children, you're right. When the victim and the appellant were alone in the house, the appellant gave the victim some lingerie, which she described as adult underwear, and not the usual underwear that she wore. The victim stated that she didn't wear lingerie at that age. I barely wore even bras. I just had sports bras, and these were like bras my mom would wear, clothes my mom would wear. The victim said the appellant asked if she wanted to try on the lingerie. She agreed, and after putting on the lingerie, she sat next to the appellant on the couch. Yes, he bought her lingerie. Remember what I said a while ago that I wondered if this culprit was um, affiliated with other culprit? You know, couldn't find out. Yeah, there was a charge about him um, having material. Before the appellant removed his penis from his pants, he moved the victim's head from her chest, and the victim performed oral sex. When the victim tried to pull away, he pushed her head down. She said she tasted something salty, so she spit it back out. See up here, I want to show you up here where, okay, I had said that earlier about that. And look right here, it said trial imposed concurrent sentences. Okay, aggravated. Okay, okay, and here is where it starts right here. It said 3 counts of aggravated sexual battery and 1 count of solicitation of sexual exploitation of a minor, but he didn't have to face that charge. See? 'Cause I was wondering if these two people were related and the other person, that younger person had that kind of material and was caught, you know? Okay. So it looks like it's true, you know what I'm saying? The victim said that on another occasion on the couch, the appellant touched her under her PJs bottoms. He touched her legs, slid his hand underneath her pants, and touched her private parts on the outside. Yeah, exactly. Usually do find out the creeps are connected when you connect the dots. Right. The victim said that later she had tried to commit suicide by swallowing pills she had taken from her grandparents' medicine cabinet. The pills caused her to hallucinate and her heart stopped. The doctors revived her and she was hospitalized for several days. After the suicide attempt, the victim told her sister what the appellant had done to her. Thereafter, she went to Rolling Hills, where she supposedly told a nurse that the appellant had sexually abused her. Subsequently, the victim spoke with Detective Knox about the abuse. She also spoke with a woman from the district attorney's office. Exactly. The victim said that after the appellant left their apartment and went to Louisiana, she called him once and asked him if he planned to return. The appellant said he was not going to return and she was sad. The victim explained that she contacted the appellant because she thought that's what you did when you had a dad. The victim said that she wasn't happy prosecuting the appellant, explaining, I was okay with doing it, but I was scared to do it at the same time. The victim acknowledged that in November and December of 2014, she and her boyfriend, Christopher Daniel Hanley, broke into people's homes and stole things. Hanley sold the stolen items to support his drug addiction. The victim said that she drove to and from the offenses, and on one occasion, she helped Hanley rob her grandmother's home. The victim had been charged with offenses in Limestone County and Morgan County in Alabama, and in Rutherford County and Williamson County, Tennessee, Wilson County, Maury County, Marshall County, and Sumner County, Tennessee. She had also been charged in Kentucky, but that charge was dismissed. The victim ultimately pled guilty and was sentenced to 10 years in Alabama and 9 years in Tennessee. She said that she had spent 4 years in confinement and that while she was in jail, her younger sister was murdered in Cannon County on January 15, 2017. Hey there, hope you're doing good, Cash. The victim was denied permission to attend her sister's funeral. The victim said that she worked at a Chick-fil-A restaurant before and after her incarceration. She said she was not proud of her criminal behavior and that she would have done things differently if she could. Though you punches Cash too. A cross-examination, the victim said the abuse occurred between September 2007 and May 31st, 2008. The victim did not recall the specific dates on which the offenses occurred, but she knew she was 12 years old when the offenses occurred. The victim acknowledged that she first made allegations against the appellant in 2012, approximately 4 or 5 years after the offenses. But really, she told the mom, and the mom did nothing about it. You remember that, Jackie? She told the mom, and the mom called her a liar and wanted to beat her up, saying, You're trying to steal my man. The victim was hospitalized because she had taken a large number of pills when she made the allegations. The victim could not recall what happened in the hospital because she was still heavily medicated. She believed she told people in the hospital her mother was a drug addict and a prostitute. The victim said she loved her mother and wanted to support her. However, because the victim was a felon, she risked being sent back to prison if she associated with her mother. The victim said that her mother's behavior towards her when she was a child had hurt her and caused her anxiety and pain. At the time, the victim did not realize her mother was on drugs, but she knew that her mother wasn't right. The victim said that Detective Knox told her that it was important to tell everything about the offenses. The victim acknowledged that her recorded statement reflected that she told Detective Knox that she had lived with her mother in the Green Meadows apartments, but that she did not recall the specific dates when they were resided there. Detective Knox then advised the victim that she had determined that the victim lived there between September 2007 and May 31st, 2008. The victim told Detective Knox that the appellant came to stay with them near the beginning of their stay in the apartment. The victim thought she told Detective Knox about the lingerie and about eating cupcakes from the appellant's mouth. She agreed, however, that in the transcript of her interview reflected that she did not tell Detective Knox about the lingerie or cupcakes, that it was fair to say she did not say they were things. The victim said she could not recall specifically what she told Detective Knox. The victim acknowledged that she knew her cooperation with Detective Knox was important and that she should tell Detective Knox everything she knew at that time. The victim asserted, I do know what I remember, and I know that for certain. Things that I remember, I know for certain. Word for word, no, I don't remember. But I know what happened to me. The victim agreed that her memory had changed from time to time. The victim agreed that when she pled guilty in Limestone County, Alabama, the court found her to be a youthful offender. The victim further agreed that regarding her pending charges in Morgan County, Alabama, she had petitioned the court to declare her a useful offender, which she thought would render her record sealed. The victim said she had told their attorney on the Morgan County cases that she was a victim of appellant's sexual abuse. On redirect examination, the victim said that she had never known her biological father. The victim said that she had not fought any of the charges against her, that she had written statements against herself, and that she had not tried to take the cases to trial. The victim thought that being in an abusive relationship with her charged partner, who was significantly older and a career criminal, had been the most beneficial factor in the dismissal or reduction of some of her charges. The victim said that she had no criminal history before her relationship with her charged partner. The victim agreed that she was trying to be as honest and tell the truth to the best of her ability in the trial. Shania Champion Richardson testified that from 2010 to 2017, she worked as a Child Protective Services investigator with the Department of Children's Services and that she was assigned to the victim's case. Champion Richardson recalled that after the victim attempted suicide, the victim told Mobile Crisis that she had been the victim of SA. On cross examination, Champion Richardson said that she first interviewed the victim in May of 2012. She also was present on one occasion when the victim was interviewed by Detective Knox. Champion and Richardson acknowledged that she had interviewed the victim's mother and grandmother, who denied any knowledge of the sexual abuse. Yeah, the mother denies it. Yeah, of course. She was on drugs. And then she tried to beat her and tried to say she lied about it, trying to steal my man. Tanis Knox testified that she worked in a special victims unit of the Criminal Investigation Division of the Murfreesboro Police Department and that she was with the detective assigned to investigate the victim's allegations. Detective Knox said that in May 2012, she received a referral from DCS regarding the victim's delayed disclosure of sexual abuse that occurred sometime in 2007 to 2008. Detective Knox confirmed that the victim lived at the Green Meadows Apartments between September 19, 2007 and May 15, 2008. As part of the investigation, Detective Knox interviewed potential witnesses. During her interview with the appellant, Detective Knox made several references to the victims being 30 years old at the time of the offenses as a tactic to get the appellant to talk more. Detective Knox acknowledged, however, that the victim was 11 years old at the time of the offenses. The state played a recording of the appellant's interview for the jury. During the interview, the appellant said that he had shacked up at the victim's mother's apartment for approximately 2 months, and that he and the victim's mother had a sexual relationship. The apartment had two bedrooms. The appellant slept in the victim's mother's bedroom, and the two children usually slept on the floor of the bedroom. The appellant thought that the victim was 30 years old and that her younger sister was 9 years old at the time. The victim's mother had a crack habit, and she left her two children with the appellant a lot. Both children were clingy and started calling the appellant daddy a day or two after he moved into the apartment. Because they didn't have a daddy. During the interview, the appellant agreed he felt that the victim liked him or was coming on to him. He acknowledged that the victim showed him some Fredericks of Hollywood panties she was wearing and told him that she got them from a neighbor. He's trying to put the blame on her. The appellant said the victim told him that she had decided she wanted to have a baby, but that he told her to stay in school. The appellant regretted not telling the victim's mother that the victim was sexually active. The appellant said that while he and the victim were sitting on a couch in the living room, she put her hand on his leg. When asked if he thought the touch was sexual in nature or was it just like a 13-year-old, the appellant responded, "Could have been both." "Do what?" "Could have been both." 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 During the interview, the appellant said the victim's mother was employed at a restaurant while he lived at her apartment, but he was unemployed. The appellant said that nothing happened between the victim and him and denied having sex with her. The appellant agreed that the victim and her sister were good kids and that they were truthful. He acknowledged that she was truthful. You see, that's where he dug himself a grave right there. See? During the interview, Detective Knox told the appellant that the victim said she had performed oral on the appellant. The appellant responded, "Wow, I don't remember that. I must have been asleep or something, you know." Appellant agreed that the victim was attractive and that he said she was built, like a woman. Oh, did give away there too. He told on himself by saying that, didn't he? Detective Knott said that she interviewed the victim twice and also interviewed the victim's mother. The first interview with the victim occurred on May 31st, 2012. However, due to malfunction, the interview was not recorded. Detective Knott asked the victim for a second interview, which occurred and was recorded on June 11th, 2012. Exactly. It is unbelievable. On cross-examination, Detective Knox agreed that she received the victim's complaint about the appellant on May 31st, 2012. Detective Knox did not take the victim to the Child Advocacy Center for a forensic interview. Detective Knox acknowledged that she did not have the victim examined medically, explaining that because of the approximate 5-year delay in disclosure, no evidence likely would be found. It wouldn't, since she even had a boyfriend since that. You know what I'm saying? That she actually, years had passed and had a boyfriend and slept with a boyfriend. Detective Knox said that she and Detective Kelvin Jones interviewed the appellant on August 12th, 2013. Yep, they always blame the child. That's right. During the interview, the appellant repeatedly denied having sex with the victim. Detective Knox agreed that her case notes reflected the victim had mentioned 4 incidents during the interview. Detective Knox further agreed that her case notes did not reflect the victim's mentioning that she removed an item from the appellant's mouth or used her mouth to take an item from his mouth or sex act following a trip to McDonald's. Detective Knox stated that she was also a forensic interviewer and that when interviewing a child, it was not uncommon for the child to fail to disclose all the events. Exactly. Yeah, then that is narcissistic behavior. At the close of the state's case in chief, but before the appellant chose whether he would testify, the state made the following election of offenses. Count one, rape of a child refers to an incident wherein the appellant, who was seated on the living room couch, exposed his genitalia and instructed the victim to get on her knees on the floor before grabbing the victim by the hair and putting his genitalia in her mouth. Wow. Count two, rape of a child refers to an incident of digital penetration. That means with the fingers, okay? Digital means with the fingers, okay? When it's talking about that, wherein the appellant entered the bathroom when the victim was taking a shower and put his finger inside of the victim's genitalia. Exactly. And she was easy access. The mother didn't care. The mother, she didn't care. Lucky some of these other guys that she was keeping in the home that were sleeping in her bedrooms, her sister bedroom, they didn't do something as well. Count three, rape of a child refers to an incident of genital to genital penetration in the victim's bedroom wherein the victim yelled out for her mother. And the mother never came. Count four, aggravated sexual battery refers to an incident wherein the appellant grabbed the victim's breast on a night she was sleeping in her mom's room situated on the appellant's side of the bed. Yep, she was on crack. Count 5, aggravated sexual battery, refers to an incident on the same occasion described above under Count 2 wherein the appellant touched the victim's breast with his hand while the victim was in the shower. Count 6, aggravated sexual battery, refers to an incident wherein the appellant touched the outside of the victim's genitalia underneath the clothes while he and the victim were seated on the couch. Here's regarding Count 7, solicitation of sexual exploitation of a minor. The state voluntarily dismissed this charge. Oh man, see what I mean? How that coincides with the other case with a guy with the same name from that I did a little bit ago, and he was 26, and this guy's 50, both for Tennessee. But the state voluntarily dismissed the charge, and that other guy earlier had videos on in his Dropbox of 41 videos and graphic pictures of children, sex acts. The appellant elected not to testify or put on proof, and the jury found the appellant guilty as charged. He, he chose not to put on proof? He chose not to testify? Trial court imposed concurrent sentences of 25 years for each rape of a child conviction, concurrent sentences of 8 years for each aggravated sexual battery conviction, in order that the 25-year sentence and the 8-year sentence be served consecutively for a total effective sentence of 33 years. See, he didn't testify or anything, but he was trying to go for an appeal. Do what? That don't make sense. On appeal, the appellant contends that the number one, the trial court erred in denying his motion for a judgment of acquittal because the evidence was insufficient to sustain convictions. But you didn't testify for it, dude. You had a chance to show if you were really innocent, that is. Two, the trial court abused its discretion by allowing the prosecutor to elicit a sorry, I can't say the word right now, irrelevant and prejudicial testimony from the state's witnesses, and three, the trial court erred in imposing consecutive sentences. Yeah, you're gonna do consecutive, man. You're not gonna get like just 20 something years. You get 25 years. Man, that's what he wanted. He wanted to add the 8 years into the 25 years, where all gets 25 years. He didn't believe he should serve all that consecutively. He believed that just doing all that for each. Oh man, it's crazy. You know. The appellant challenges the trial court's denial of its motion for a judgment of acquittal, which was made at the conclusion of the state's proof. Standard by which the trial court determines a motion for judgment of acquittal at the time of all the proof is, in essence, the same standard which applies on appeal in determining the sufficiency of the evidence after a conviction. State versus Thompson. Before we address the appellant's complaint as a challenge to the sufficiency of the evidence. On appeal, a jury conviction removes the presumption of the appellant's innocence and replaces it with one of guilt, so that the appellant carries the burden of demonstrating to this court why the evidence will not support the jury's findings. Appellant must establish that no reasonable trier of fact could have found the essential elements of the offense beyond a reasonable doubt. Accordingly, on appeal, the state is entitled to the strongest legitimate view of evidence of all reasonable inferences which may be drawn therefore. In other words, questions concerning the credibility of witnesses and the weight and value to be given the evidence, as well as all the factual issues raised by the evidence, are resolved by the trier of fact and not the appellate courts. The guilt of the defendant, including any fact required to be proven, may be predicated upon direct evidence, circumstantial evidence, or combination of both direct and circumstantial. Even though convictions may be established by different forms of evidence, the standard of review for the sufficiency of that evidence is the same whether the conviction is based upon direct or circumstantial. Rape of a child is the unlawful sexual penetration of a victim by a defendant if the victim is more than 3 years old but less than 13 years old, which she was. Sexual penetration means sexual intercourse. Condemn, oh, I don't want to say all these words because, all right, or any part of the person's body or any object into the genital and other openings of the victims, dependents, or any other person's body, but emission of semen is not required. Aggravated sexual battery is unlawful sexual contact with the victim by the defendant. The victim is less than 13. It's defined as the intentional touching of the victim's intimate parts or the intentional touching of the clothing covering the immediate area of the victim's intimate parts. If that intentional touching can be reasonably construed as being for the purpose of sexual arousal or gratification. The appellant's complaints about the sufficiency of the evidence sustained in his convictions concern the credibility of the victim's testimony. Yeah, yeah. Some of the words, they kind of, you get in trouble at the site right here for saying some of the words, so I'm trying to be careful about saying it too. The appellant asserts that the only direct evidence implicating him was the victim's testimony and that her testimony was inconsistent and not credible. The appellant contends the victim had problems with her memory due to her suicide attempt, that some details of the incidents varied between her trial testimony and her statement to Detective Knox. The appellant also complains about the time that elapsed between the offenses and the time the victim reported the abuse and the victim's failure to seek help from the mother. The victim tried to get help from the mother, but the mother, oh, well, our Supreme Court has held that the jury, as a trier of fact, is empowered to assess the credibility of the witnesses, to address the weight to be given their testimony, and to reconcile any conflicts in the proof. With a down stating the weight and the credibility of the witnesses' testimony are matters entrusted exclusively to the jury as a trier of fact. Our courts have repeatedly held that the testimony of a rape victim is sufficient, standing alone, to sustain a conviction. In the instant case, the victim testified that she told her mother about the appellant's abuse, but that her mother, who was a drug addict, accused her of lying. The victim did not reveal the abuse again until many years later after she attempted suicide. The victim explained that any inconsistencies in her testimony could be attributed to the length of time that elapsed between the offenses and the allegations because she had tried to forget what happened to her. Moreover, Detective Knox testified that it was not uncommon for a victim of SA to omit details during an interview. The jury heard the proof and clearly resolved the issue of credibility in the state's favor. We may not now reconsider the jury's credibility assessment. The victim gave detailed testimony about each instance of rape of a child and aggravated sexual battery. We conclude that the proof was sufficient to sustain the appellant's convictions. Improper questioning of state's witnesses. The appellant contends that the state asked improper questions which were irrelevant and were intended to inflame the sympathies, passions, or prejudices of the jury. When, when you go like that, you gotta have compassion for the child that was raped, right? You gotta have sympathy for the child. The appellant specifically contends that the state asked improper questions of the victim regarding her mother's role in her life as a result of her mother's drug use and incarceration, the murder of the victim's sister, and the victim's inability to attend her sister's funeral due to her incarceration. Don't make sense for him to even bring all that up. The appellant also complains that the state's asking the victim a redirect examination and the victim had tried to be honest during the interview with Detective Knox. The appellant further complains that on redirect examination after Detective Knox testified she interviewed the victim on two occasions, the state asked, "Did you? Was her account consistent between these two interviews?" Detective Knox replied, "Yes, her accounts were consistent." The appellant argues that the detective's answers to the questions were improper comments on the evidence. Of course, because the first set they were not recorded, okay? So the appellant said, well, we can't really go by that because the first one wasn't recorded. He's tried everything in his book to get out of what he had done. Children never get the support they really need. Exactly. Damage is done. Makes me angry as well. So initially, we note that the appellant objected to only two of the state's questions. First, when the state asked on redirect examination if the victim had tried to be honest during the interview with Detective Knox, defense counsel objected to bolstering, but the objection was overruled by the trial court. On redirect examination, after Detective Knox testified she interviewed the victim on two occasions, asked, "Did you, was her account consistent between these two interviews?" Defense counsel objected on the basis that the answer calls for conclusion. The trial court overruled the objection, stating, "I think she can answer this. Go ahead." Detective Knox responded, "Yes, her accounts were consistent." They didn't want her to be able to say that, did they? On appeal, the appellant maintains that the detective's answer was an improper comment on the evidence. The state contends that the appellant cross-examined the victim about her credibility and motive to lie, and that in response, on redirect examination, the state was allowed to ask the victim if she tried to be honest during her interviews with Detective Knox. The state also maintains that after the appellant attacked the victim's credibility, there was nothing impermissible in the state prompting the victim to defend her own credibility by explaining her prior or inconsistent statement and by affirming that she was testifying truthfully. The state contends that the purpose of asking Detective Knox whether the victim's two interviews were consistent was to inform the jury that the substance of both interviews were the same, given that there was only a recording of the second interview. The state notes that the defense counsel had used the victim's recorded interview to impeach the victim on cross examination, had asked specific questions about both interviews, thereby raising the subject. The state asserts that if any error existed in allowing the question to be asked, the error was clearly harmless. We agree with the state. The record reveals that during the cross examination of the victim, defense counsel asked whether the victim knew that it was important to tell Detective Knox everything during the interview and that defense counsel asked additional questions challenging the victim's credibility during the interviews. Accordingly, we conclude that the state's questions were clearly a response to defense counsel's challenge to the victim's credibility. Thus, the trial court did not err by permitting the question. On appeal, the appellant further challenges Detective Knox's response as improper lay opinion under Tennessee Rule of Evidence 701. However, the appellant did not challenge Detective Knox's testimony on this basis in the lower court. Generally, a party is bound by the evidentiary theory argued to the trial court and may not change or add theories on appeal. Therefore, a defendant may not object to the introduction of evidence on one ground, abandon this ground, and assert a new basis or ground for the objection in the court. I'm glad that they had that. On appeal, the appellant acknowledged that he did not contemporaneously object to the remaining questions but contends that he is entitled to plain error of truth. The state maintains that by failing to raise contemporaneous objections, the appellant has waived the issues and that the appellant is not entitled to plain error relief. We agree with the state, so that Tennessee Rule of Appellate Procedure provides, when necessary to do substantial justice, this court may consider an error that has affected the substantial rights of a party at any time, even though the error was not raised in the motion for a new trial or assigned as error of appeal. We may only consider an issue as plain error when all five of the following factors are met. A. The record must clearly establish what occurred in the trial court. B. A clear and unequivocal rule of law must have been breached. C. A substantial right of the accused must have been adversely affected. D. The accused did not waive the issue for tactical reasons. And E. Consideration of error is necessary to do substantial. It says, furthermore, the plain error must be of such a great magnitude that it probably changed the outcome of the trial, but didn't. Generally, questions concerning the admissibility of evidence rest within the sound discretion of the trial court. This court will not interfere with the absence of abuse appearing on the face of the record. The trial court abuses its discretion when it applies an incorrect legal standard or reaches a conclusion that is illogical or unreasonable and causes an injustice to the party. So basically, we can go on down, and it says that appellant contends that the questions about the death of the victim's mother and her mother's drug addiction were unfairly judicial because they were intended to inflame the sympathies, passions, or prejudice of the jury. No, not really. She just stated matter of fact, that my mother was on drugs during this time when the appellant was in their life. Just stating a fact. The state maintains that the questions about the victim's sister and mother were relevant to explain why the victim was alone with the appellant and why the victim's sister and mother were unable to corroborate her testimony. The state further maintains that the victim needed to explain why her prior incarceration was not something that she took lightly. The state asserts that any error by allowing the question did not render the appellant's trial fundamentally unfair. The state further alleges that the appellant's failure to object may have been a tactical decision to avoid the risk of offending the jury by appearing to thwart the victim's attempt to tell her side of the story. So the state's questions regarding the victim's mother and sister largely dealt with their inability to verify the victim's version of events, which was relevant to the issues at the trial. The victim's testimony revealed that because of her sister's death and her mother's drug use, they were unable to testify about the events. We acknowledge that the state's questions regarding the manner of her sister's death, the victim's inability to attend her sister's funeral, and the victim's disappointment in being unable to say goodbye to her sister were not relevant and therefore should not have been addressed. However, we conclude that the appellant is not entitled to plain error relief because consideration of the error is not necessary to do substantial justice. All right, now here's the citizen. As his final issue, the appellant challenges the trial court's imposition of consecutive sentencing. As a citizen hearing, the state submitted to the appellant's presence report as an exhibit. Pre-sentence, report. The state said that it would rely upon the proof adduced at trial. In an allocution, the appellant claimed that the victim was cutting, that she devoted herself to deceit, and that she poured out her heart to lies. Remember earlier, he said in a testimony that you could trust her, that she was truthful. And then now that she came and spoke about him doing this? Oh, she's full of lies. The appellant maintained that he was innocent of the charges against him. The appellant said that he had wanted to subpoena the victim's mother and have her watch a video of the victim making those false allegations. The appellant said that he assumed that these things happened to the victim because of her performance at the trial and the conviction of her testimony that her assailant must live in Murfreesboro, that the victim must be afraid to confront the person. The appellant was the perfect place to accuse because he was living in California or Vegas. He maintained that the victim had to play along in order to stay out of prison. Yeah, right. See, he wanted to do those accusations and let the mother watch and record the mother's. That's going to further traumatize the girl. That would further traumatize her. The mother, of course, is going to deny it. Crazy. The trial court stated that it had reviewed the pre-sentence report and the sentencing guidelines and had considered the nature of the conduct involved and the statistical information provided by the Administrative Office of the courts. Trial court also examined the factors of the case and found that the prior criminal offenses appeared to be minor. The trial court imposed the minimum range 2 sentence of 25 years for each of the three rape of a child convictions. The trial court likewise imposed the minimum 8-year sentence for each of the three aggravated sexual battery convictions. To consider whether to impose consecutive sentences, the trial court noted that the case concerned multiple convictions of two or more statutory offenses involving sexual abuse of a minor. Therefore, the trial court examined the aggravated circumstances stemming from the relationship between the appellant and the victim and noted that the appellant was a boyfriend of the victim's mother, that he was living with them at the time of the offenses, and that the victim called him daddy. Regarding the time span of the undetected sexual activity, the trial court observed this was not discovered until the child turned 16 and attempted suicide. The trial court also found that the victim had significant residual physical and mental damage. The trial court ordered the 25-year rape of a child sentence to be served concurrently with each other and the 8-year aggravated sexual battery sentences to be served concurrently with each other but consecutively to the sentences for rape of a child for total effective sentence of 33 years. They reviewed all that and determined a specific sentence within a range of punishment. The trial court should consider but is not bound to the following advisory guidelines. So they went along with that. I don't think we need to read all of that. Okay. And it said, okay, right here is important right there. On appeal, appellant contends that the trial court erroneously determined that consecutive sentences shall be applied under Tennessee Code annotated section 4035 115B. After determining that the length of the undetected sexual activity should be determined by the span of time between the abuse and the discovery of the abuse instead of the span of time during which the abuse occurred. The appellant complains that he resided in a residence with the victim for only a few months, despite the trial court statement that there was a time span with regard to the undetected sexual activity that's to be considered as part of the statute. This was not discovered until the child turned 16 and attempted suicide. Although the victim was unable to recall when the offenses occurred and thereby could not assert the time span during which the offenses occurred, the court previously has stated that not all of the aggravating circumstances listed in section must be present to support the imposition of consecutive sentences. The court explained that consecutive sentences may still be appropriate under a certain section. Let's go on further down now. We note that the trial court found the appellant was the victim's mother's boyfriend and the abuse occurred during the months the appellant lived with the victim's family. Undisputably, the victim referred to the appellant as daddy and viewed him as a father figure. The appellant had control of much of the victim's care, and he abused a position of private trust by molesting her while she was under his care. Trial court found that the victim had residual mental damage from the abuse. Indeed, the record reflects that the victim attempted suicide because of the abuse. We conclude that the trial court did not err by imposing consecutive sentences. Finding no reversible error, we affirm the judgment of the trial court. Thank God. Thank God. Well, thank you all for coming and everything. And I wanted to get this out. And the damage is done. And they did see some other damage for it, um, physically. Of course, when you mess with a child at a younger age, it's going to have damage. And they did find some physical damage as well, as I stated. Uh, but my heart goes out to this lady for being brave enough to stand up against this, to go against her mother. Yes, exactly. Exactly. Yes, like it affects me, and now majority of the perpetrators who did that to me are dead, but they got to face their own judgment. Well, thank you so much for coming, and I just had to get this out there. And next one that I'm going to do is at 3 o'clock when they're searching for a woman that shot a 10-year-old child and killed him. That's going to be in a couple hours. Well, an hour and 30 minutes. No, it's almost 3 o'clock now, ain't it? All right. Well, thank y'all, and God bless y'all. Thank you so much. Yeah, they need somebody to speak out for them. You know what I'm saying? And I do see a connection between the two people that's got this name, Derrick Himes, 50-year-old, and Derrick Himes, 26-year-old. Like I said, having that kind of material on the internet, saving that into Dropbox. And then this guy actually did have that as one of the charges, but the state went ahead and dropped that charge. Thank you so much, and I hope you get plenty of rest, and thank y'all for coming, you and Cash. God bless y'all, okay?